Hello, and welcome to the latest episode of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners re-domesticate out of volatile legal and tax environments like the formerly golden state of California to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, I am reviewing a report by Nick Fidles, writing for the Financial Times, entitled "Every Dollar is Mobile: California's Rich Snap Up New Zealand Golden Visas," referring to one aspect of the ongoing mass exodus of business owners and families from California. I will then conclude by explaining how small and medium sized businesses can utilize the same laws to their advantage to relocate out of California or out of another jurisdiction to a new state while keeping their existing federal employer identification number, contracts, and bank accounts intact. But first, a brief introduction. My name is Chad Daniel Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 12 professional licenses and certifications spanning accounting, tax, audit, financial planning, and of course, the law. My firm website is www.cummings.law. There is a story out of New Zealand this week that says more about California than it does about the South Pacific. The Financial Times reports that a veteran polar explorer will soon lead 8 wealthy new arrivals on a 2-day expedition into the Southern Alps. You might be thinking, what the heck does this have to do with business law? Well, we'll get to that in just a sec. This is a reward arranged by a very posh private members club for people who bought their way into the country under its so-called Golden Visa program. The chief executive of that club described his ambition in plain terms: figure out how to turn someone who spent 5 million New Zealand dollars into someone who invests 500 million. The numbers behind the party are the real story. More than 700 wealthy foreigners applied for the New Zealand Golden Visa program in the past 14 months. In the previous 3 years, the total was 115. The entry price is 5 million New Zealand dollars, roughly 2.9 million US dollars, committed to local funds, companies, or charities within 36 months. Another 127 applicants chose a second track, requiring 10 million New Zealand dollars over 5 years in passive assets, such as bonds. Since the program was overhauled in April of 2025, applicants from North America, Europe, and Asia have committed a staggering 4.8 billion New Zealand dollars to the program. Americans filed 277 of those applications, and Californians, not surprisingly, lead the pack. And no, we're not talking about Mark Zuckerberg's doomsday bunker, although I imagine he's one of them. That's just speculation. I don't know that for a fact. One venture investor there described the Golden Visa as a badge of honor in Silicon Valley. I would go a step further and say it's become a kind of status symbol, for better or worse. A property agent spent 3 weeks in June working prospects in San Diego and Beverly Hills, reporting that many had already visited New Zealand. In Queenstown, the town where most of them land, locals call the arriving billionaires sleepers in the hills. Median home prices there now sit at 1.8 million New Zealand dollars, twice the national average, and visa holders are barred from buying anything under $5 million. Prime Minister Christopher Luxon says the money and the knowledge arriving with it are reversing a brain drain. No, not everybody agrees. The managing director of a New Zealand pension fund objected that people should be properly invested in the country rather than buying preference with a small check. Then comes the detail that undercuts the entire arrangement. A California fund manager who obtained a visa last year complained directly to the prime minister that her family would be taxed on their worldwide earnings if they spent more than 183 days a year in the country. I can tell you from this complaint, this individual probably was relying on inaccurate and incomplete advice on Reddit and AI rather than sitting down with an international tax attorney who could have told her that in 30 seconds, certainly before committing the resources and time necessary to obtain a golden visa in New Zealand. Her conclusion was that if New Zealand fails to deliver value, they will go elsewhere because, according to the quote, every one of those dollars is mobile. Again, sounds like a case of buyer's remorse, somebody who didn't do their homework. But she is correct, and she crossed an ocean to learn something that she could have learned in just a few minutes. And by the way, she didn't necessarily need to go to New Zealand. She could have gone to a no income tax state like Florida or Texas for a heck of a lot less time and money. Neither Florida nor Texas impose a personal income tax. There is certainly no minimum investment, no committee reviewing whether you are the right sort of investor, whatever that means, no $5 million property floor, no day count that converts your global income into somebody else's tax base. Although there are certainly aspects of multi-state taxation which are beyond the scope of today's presentation, which we have covered in earlier presentations on Legal Bites. Tax Foundation data indicate the average business relocating to a state without income tax retains more than $12,500 each year, sometimes significantly more by orders of magnitude, depending upon the size of the business and the specific circumstances. Now, California, New York, Illinois, and New Jersey built their state budgets on the false assumption that residents were captive. They are not. Ireland, Malta, and Australia already canceled their own golden visa schemes. The dollars kept moving anyway. And some of them, some of the options, like Florida, like Texas, require no passport at all. Remember, not only do Florida and Texas not impose a state level individual income tax, but most small and medium sized businesses in these two states pay no business level income tax either, at least on income sourced to that state. Now, with this context in mind, redomestication is the lesser known legal process of transferring a company's state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income tax consequences, but only when performed within the strict formalities required under the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When performed by a competent professional, and that is an important proviso, the company will retain its existing federal employer identification number, contracts, credit history, and bank accounts. All of that to say there is zero operational or financial disruption, but only if you get it right the first time. That is why it is imperative to work with a credentialed and experienced professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states, yes, including California, and for limited liability companies, partnerships, subchapter S corporations, and subchapter C entities. So if somebody is telling you it cannot be done, generally, or more specifically, you cannot redomesticate out of California, they are years behind. California has allowed redomestications of LLCs and corporations for a number of years now. So what they're really telling you is they don't know how to do it and they can't be bothered to learn. Make of that what you will. Now, foreign entity registration is not the same thing as redomestication, because foreign entity registration, also referred to as foreign qualification, does not change the company's domicile, regardless of what you read on Reddit, which was posted by some armchair expert without any credentials. In fact, it keeps the entity in the former, if I sound a little salty on that, I am, but that's another story for another day. Foreign entity registration keeps the entity in its former state, California in our example, indefinitely. So you're still paying the California Franchise Tax Board, and merely adds another layer of compliance and tax obligations in the destination leaving you anchored to the state you thought you were leaving. Meanwhile, a traditional merger, which is also not the same thing as redomestication, creates a new distinct entity in the destination jurisdiction, may and often does require the issuance of a new distinct federal employer identification number and can trigger serious tax consequences. Finally, dissolution should not enter the conversation at all because dissolution terminates the company. Dissolution is a going out of business maneuver, not a relocation mechanism. Dissolution is often a taxable event and, when performed incorrectly, can expose the owners of the company to unlimited personal, let me say that again, unlimited personal, joint, and several liability for the company's liabilities known and unknown. That is because the so-called veil of liability protection no longer exists because the company no longer exists. That's just simple logic. So if you think dissolution is a shrewd cost-cutting mechanism, you may be in for a rude awakening. And if you have a so-called professional suggesting dissolution as a relocation stratagem, please seek better advice before you make a mistake you cannot undo with Control Z. Redomestication, when paired with a change of personal residency and that is a very important and, a reduction or outright cessation of business operations in California, can reduce or even eliminate state tax nexus exposure there for the entity and its owners. Don't take my word for it. Ask your CPA. Now is the time to consider acting before the California legislature in Sacramento considers changes to California law to hinder or even eliminate the possibility of redomestication. If you have questions regarding potentially redomesticating your existing limited liability company or corporation out of California or out of another jurisdiction, please utilize the link in the description or in the bio for more information on this process and to schedule time for you and I to speak one-on-one about your specific situation. Again, my name is Chad Daniel Cummings of the firm Cummings and Cummings Law. And I hope that you found this information informative. As always, the information in this presentation, like all of my presentations, is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on these topics, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.